being aggrieved by the impugned order in IA number 2 filed under Order 39 Rule 1 and 2 and Section 151 of CPC in OS number 134 2021 dated 30/10/2021 on the file of Civil Judge and JMFC Mudabidri, the appellant has preferred this miscellaneous appeal. The appellant is the plaintiff and the respondent is defendant number 1 in the original suit. For the sake of convenience, they are referred to as they are referred in the original suit. The brief facts leading to this miscellaneous appeal are as follows. Initially, plaintiff had filed this suit seeking relief of permanent injunction restraining the defendants and their men from trespassing into the plaintiff scheduled property to do any illegal acts affecting his legal right. In the suit, an interim application in IA number 2 under Order 39, Rule 1 and 2 and Section 151 of CPC is filed for restraining defendant number 1 and 2 from trespassing and dumping mud in the plaintiff scheduled property. According to the plaintiff scheduled property was originally purchased by his mother through registered sale deed. After her death in the year 2017, he is in possession and enjoyment of the said property along with his brothers and sisters. To the south adjacent side, the property belonging to defendant number 1 bearing system number 78, survey number 78/11 of Minnabettu village exist. The southern survey line of the plaintiff's property is the boundary line between the above two properties. When the things stood thus on 7/9/2021 at 9 a.m., defendant number 1 and 2 in furtherance of their intention to trespass into the plaintiff's property have dumped one load of mud. Though he resisted their illegal acts, they have threatened to dump furthermore loads of mud to enter the plaintiff scheduled property. Defendants would bring into action their threat. Hence, he filed IA number 2. Defendant number 1, after service of notice, having put on his appearance, denied the plaint averments and contended that he is the absolute owner of written statement 10 scheduled property. The same is acquired by him as per sale deed dated 21/2021. Since then, he is in actual possession and enjoyment of written statement X scheduled property as absolute owner. The written statement 10 scheduled property is full subdivision property. The boundaries of the property is accurate as per the sketch annexed to the sale deed. He has put up trenched fence to the said property. He had conducted survey, haddubastu, and boundaries were fixed by the competent surveyors. Therefore, there is no confusion in respect of boundaries of written statement 10 scheduled property. Therefore, the entire allegations made in the plaint is just a false story created for litigation. The plaintiff claiming to be having right, title and interest in the adjacent property of written statement 10 scheduled property and is trying to obstruct for the development work carried out by him. The plaintiff do not have any right, title and interest over the written statement 10 scheduled property. Hence, prayed for dismissal of the suit with exemplary cost. After hearing the arguments of both parties and after perusal of materials placed on record, trial court dismissed IA number 2 filed under Order 39, Rule 1 and 2 and Section 151 of CPC by order dated 30/10/2021 impugned in this appeal. Being aggrieved by the said order, the plaintiff bar appellant preferred this appeal, assailing the following grounds. The order of the trial court is contrary to law and probabilities of the case. Trial court has not properly verified the contents of the application filed by the appellant and dismissed the application by misapplying the relevant provisions of law. Trial court has not properly framed the points for consideration on the basis of the pleadings of the appellant and answered all the points as negative. Trial court has not considered the question of law involved in the proceedings and not verified the important documents which are against the case of the respondent. The so-called sale deed contended by the respondent is not having any legal value as it is done without following the procedures and not included all the parties who are having right to execute any sale deed in favor of the respondent. Trial court should have passed an order to maintain status quo against the parties until the suit is finally decided. During the disposal of IA number 2, there are two other applications pending. One is filed by the respondent to measure and identify his property, and another application is filed by the appellant to give police assistance to implement the court order. But the trial court, instead of disposing two applications, dismissed IA number 2 without giving any proper answer to IA number 2. Trial court should have passed an order not to do any work or dump mud in the property of the plaintiff until the defendant proves that he has validly purchased the property from other defendants. Trial court should have considered the dictum given by the Honorable High Court and Supreme Court that if there are points to be considered during the trial stage, then the status of things should have been maintained by the respondent, but unfortunately, trial court, without understanding what is the prima facie case, balance of convenience and irreparable injury, has dismissed the application of the appellant without considering that if injunction is not granted to the appellant, then the respondent will dispossess the appellant from the suit property on the pretext of his so-called sale deed. By contending as above, amongst the other formal grounds, appellant prayed to set aside the order passed by the trial court, heard both parties on the merits.